And now to our interview segment. My guest, Mr. Asue Ighodalo, specializes in advising major corporations on matters of corporate finance, energy, and natural resources, to mention a few. He sits as a director on the boards of several companies and NGOs, including the Nigerian Economic Summit Group. He is also the chairman of the Nigerian Bar Association section on business law. One of the key objectives of that session is to ensure that businesses thrive in the Nigerian environment, and these form the core of my discussion with Mr. Ighodalo. Last year, Nigeria was ranked 169th by the World Bank on the ease of doing business reports. Ghana was ranked 70th, and this was one of the issues that the lawyers under the aegis of the Nigerian Bar Association section on business law discussed at its conference. Now, Nigeria has further fallen in the rankings to 182. What has happened to the fallouts from that conference?
At the end of last year's conference, we prepared a report, and one of the things we did was we had an executive summary of what needed to be done, and we categorized immediate to-dos, medium term, longer term. And we presented that report to participants, but specifically to the Vice President and also to our regulators. And hopefully, some of them have been working on the outcome of that report. But specifically, we as the SBL, since that conference, we've engaged with the Corporate Affairs Commission through the Registrar General. We had a session with the Registrar General and his team, and from that session, we decided to set up a committee of 3 members of the Registrar General's team, 3 high-ranking members of the Corporate Affairs Commission, and 3 members of our council. And what this committee is doing is looking at the workings of the Corporate Affairs Commission, looking at the practitioners, their needs, their complaints, and trying to ensure that the needs and the complaints of practitioners are met by the Corporate Affairs Commission, trying to ensure that the Corporate Affairs Commission works much better, works more efficiently. A lot of work has already been done by the Registrar General and his team to making the Corporate Affairs Commission more responsive to the needs of practitioners and to the public. So we're working very close together, and we're working symbiotically to ensure that the Corporate Affairs Commission, being the first one-stop regulator place for investors coming into Nigeria, it's the foundation of establishment of companies. It's the regulator for companies, the first point of regulator regulator and regulation of companies. So the symbiotic effect of the work we're doing is showing in the effectiveness of the Corporate Affairs Commission, and we thank the Registrar General for this work. We're also engaging with some other regulators in this time, and particularly the SEC. We're trying to ensure, the Securities and Exchange Commission, we're trying to ensure that the work of the SEC and the work of practitioners also, there's a symbiotic relationship. We're interrelating. SEC, when it's going to come out with any of its new rules, exposes those rules to practitioners, and we have the opportunity to comment and make suggestions to those rules. So I think from our last conference, we can point at successes and paths that we have trod on that are improving the business climate. Now, a lot more needs to be done. We acknowledge the work that's been done by the current National Assembly, the 8th National Assembly. On Monday, the Senate President had a gathering of industry practitioners, legislators, business people, and technical people to look at those laws that needed to be either amended, repealed, or enacted to improve the ease of doing business in Nigeria. And that's a great first step. So a lot of work is going on from different angles, and the way I'm seeing the commitment of the federal government, the executive, the Minister for Industries, Trade and Investments, the presidency, and the legislature. The commitment I'm seeing from them, I expect that maybe in the next 1 year, we will have a significant improvement in our ease of doing business rankings. I expect so.
I hear you talk about laws that need to be enacted, laws that need to be repealed, and laws that need to be reformed. Can you tell us specifically which laws the National Assembly should focus on?
For instance, if you look at the base law for business in Nigeria and for company formation, the Companies and Allied Matters Act, it's a 1990 law. That's 26 odd years. There needs to be a lot of work and reform to catch up with the moving dynamics of the business environment, for economic development, for ensuring that setting up companies, regulating companies, governing and running companies is made more effective and easier. So there's certain suggestions that have been made for the amendment of that particular law. So the National Assembly, that's the Companies and Allied Matters Act. So the legislature is looking at that. Competition, we've been trying since at least 2000, that I'm aware of, to enact a competition bill. In a deregulated environment, we shouldn't transfer from public monopolies to private monopolies. So you would require a law like a competition or consumer law that would help ensure that you properly regulate corporates and big companies in this space, so as to avoid antitrust and competition issues. So that's one law that has been in the National Assembly for about 16 odd years, and it hasn't been enacted. It hasn't seen the light of day. It's gone through many formations, but it hasn't seen the light of day. So I think that it's a really technical area. It's a technical law, and I think by the time legislatures are getting to grips with the technicalities of that law, their tenure is over, and then the next legislature comes in and they start the process again. And there have been different issues around it. So I think that's probably the major reason why it hasn't been passed into law. I think there's a stronger commitment on the part of this assembly to pass that particular piece of legislation into law. And it's one of the laws that one of the bills that is being looked at and is being reviewed at present. I know the executive is reviewing it, the legislature is reviewing it. Even industry practitioners are looking at it and making their suggestions. And I think we're still early in the life of this assembly, and they still have about 3 years. And no matter the work we do, in the next hopefully year and a half, the National Assembly should pass that bill into law. The Securities and Exchange Commissions Act, it needs review. It needs to be improved in certain places. For me, the NIPC Act, when the NIPC Act was being considered with the Nigerian Investment and Promotion Commission Act, we thought we were going to have a one-stop center where anybody that wanted to establish a business or do business in Nigeria would go to one place, and you didn't have to go to many places. That was the thinking for that act. But it has transpired that it has just become another regulator or another toll gate or another source of going to get approvals. So all of the other sources are still there, and this one is an addition. So that's not how it was meant to be. So that we need to look at that act. We need to see how we can tinker with it to make sure that we get the original objectives right. The Immigration Act, we need to make life easy for people who are genuinely coming here to do business, people who are genuinely coming here to work, people who are coming into Nigeria. We need to be able to give. I know we've improved over the years. There's a facility at the airports for genuine business people coming to Nigeria to get their visas at the airport, if they have their papers complete. But we need to ease it. We need to make it easier for people to come into Nigeria and do business. And there are a lot of genuine business people that get frustrated trying to come into Nigeria. It's difficult getting visas at many of our embassies. The South African embassy, the British High Commission, our embassies in the United States. We shouldn't make life that difficult for people. So we need to look at all of these laws. My own feeling, and I was having a conversation with Professor Idonije, who was involved in reviewing these laws and then collating and presenting for review. And I told him that, we need to take it in batches. Let's look at the 6 most important laws that we need to review, repeal, or enact, and let's present those to the National Assembly and let them work on those, then they pass those, and then we can look at the next batch. What we have is that we have high importance, medium importance, low importance. I think we need to do them in those batches, the first 6, the next 6, and then we will see some traction. When we were in Abuja for the last economic summit, there was the presentation from Georgia, and they kind of told us how they moved from a ranking as low as ours to a top 10 ranking in the world in a space of about 2.5 to 3 years. So it's something that's possible, something that we can do. It just requires the effective commitment.
But where does the responsibility lie for getting all of this done?
It's the responsibility of all of us. It's government's responsibility, executive and legislature, but it's not just that. Even the judiciary, those of us who are practitioners, and even the public, it's key. It's key for all of us to come together to ensure that the legislature is doing what it should do, that the executive is doing what it should do. And going into our conference in June, that's part of what we're focused on. Because our conference in June, that's the section on business law annual international conference. Our conference in June is focused on law reform and economic development. And so we're focusing on it because it's key for now. Everybody's talking about where are we in our economy? Why are we where we are? Why are we not diversified? And we think the base is law reform. If you have a strong legal base, then you can build on that legal base.
And just before we go, the Ben Nwabweze Center for Studies in Constitutional Law has held its inaugural law conference with the topic Code of Conduct and its crucial importance in the fight against graft. We have details in this report.
In months past, the trial of the Senate President, Dr. Bukola Saraki, at the Code of Conduct Tribunal has raised lots of controversy, bringing legal minds to a debate as to whether or not the tribunal is a court that can hear and adjudicate on criminal matters. The Supreme Court had earlier dismissed an appeal by the Senate President against this trial by the Code of Conduct Tribunal for alleged false assets declaration.
My Lord, I haven't had the opportunity to say it, but I remember there was a major case being done.
These issues form the crux of the discussion at the inaugural lecture of Ben Nwabweze Center for Studies in Constitutional Law and other related subjects.
Let me just say one thing. The crucial importance of the Code of Conduct in the fight against corruption. Some people say that I am against the war against corruption. No, I'm not.
First, the issue of whether the Code of Conduct Tribunal is a court of law.
Nothing in my candid view can be more definite that jurisdiction over criminal offense arising in whatever shape or form from the wording of the act is taken off the tribunal, but belongs exclusively to a court of law. To put it plainly, the tribunal has no criminal jurisdiction under the act establishing it and cannot exercise it under any pretext.
Then, whether or not the Code of Conduct Tribunal is right in refusing to grant a request proceedings in a case before it.
The first and the most noteworthy distinction that I intend to make is that under Section 318 of the 1999 Constitution, members or officers of the other tribunals not specifically mentioned as courts under Section 6, Sub 5 of the Constitution, including the Code of Conduct Tribunal, are not included in the list of judicial officers.
The question on the constitutionality of the Code of Conduct Parole and Tribunal Act is answered by Senior Advocate of Nigeria, Mike Ozekome.
Paragraph 15 of the 5th schedule to the Constitution and paragraph 18 to the 5th schedule of the Constitution created the Code of Conduct Bureau and Code of Conduct Tribunal Act, Code of Conduct Tribunal. There shall be established a tribunal to be known as the Code of Conduct Tribunal, which shall consist of a chairman and 2 other persons. A chairman and 2 other persons. And their job is simply to enforce compliance with the Code of Conduct, and then the other one is to try offenses regarding breach of this Code of Conduct.
This is the first of the series of lectures to be held by renowned constitutional lawyer Professor Ben Nwabweze, Senior Advocate of Nigeria. Subsequent lectures will dwell on subjects related to political and national issues.
And it's on that note we wrap up this episode of the program. If you missed any part of it, you can find it in past episodes on our YouTube channel. Do also interact with us via Facebook, email, or Twitter. I am Shola Shieli. Thank you for watching.